Welcome to the deep dive. Today we're jumping into a really intricate, but actually pretty universal kind of legal strategy. We're looking at how you navigate those complex legal challenges that pop up during big corporate changes, specifically focusing on employment and pensions. Think of this deep dive as your shortcut to getting smart about a very specific, very detailed legal approach. So that the sources we're working from today, they lay out this detailed legal brief. It's basically the best approach for someone, an individual who's facing, well, unlawful termination and pension issues after a corporate takeover. Our mission really is to pull out the key nuggets of wisdom from this strategy to show you how powerful a really well put together legal challenge can be. Okay, let's try and unpack this a bit. Imagine, you find yourself in a situation, your job, your pension, it all gets tangled up because the company structure changes. What's the smartest way, the most efficient way to untangle that legally?
Well, what's really interesting here, based on our sources, is how taking a unified approach can just make the whole case so much stronger. The best strategy, it seems, isn't tackling these things one by one. No, it's integrating both the termination claim and the pension mismanagement claim into a single, powerful document, a pre-action protocol letter.
Right, a pre-action protocol letter. For anyone not familiar, what exactly is that in simple terms?
Think of it like the formal warning shot. It's what you send before you actually file a lawsuit. It's this detailed letter that lays out your entire case, what you're demanding, and makes it clear you will go to court if you don't get a resolution. It's a really critical step in places like Trinidad and Tobago and many other jurisdictions too. And here, it's not just about ticking a box, it's strategic.
Okay, strategic. So why is combining these claims so effective?
Well, several reasons jump out from the sources. First, it creates what they call a unified legal strategy. You bundle the claims, right? So you're presenting this cohesive story. You're showing these aren't just separate problems, they're linked. Like if RBC terminated the employee but they're still managing their pension, that kind of contradicts the whole termination idea, doesn't it? It forces the company to see the whole picture, makes it harder for them to sort of brush things off separately.
Okay, interconnectedness makes sense. What else?
Second, it's about leveraging the legal framework. The sources really stress this. You explicitly call out the specific legal steps required for pension transfers. Things like, formal amendments to the trustee, properly notifying employees, getting approval from regulators like the Central Bank of Trinidad and Tobago. These are the watchdogs, right? They make sure pensions are handled correctly. So, by pointing out these specific requirements, you add serious weight to the claim that they breached their fiduciary duty. It challenges their authority and, potentially, exposes where they failed procedurally.
Right, highlighting the rules they might have broken.
Exactly. Third, there's efficiency and urgency. A single letter means all the issues hit their desk at once, and that starts the clock on that strict 14-day notice period for everything. If you send a separate letter just asking about the pension, well, that could slow things down. Or, maybe worse, it might let the company treat the pension as some side issue, less urgent. This keeps the timeline tight, keeps the pressure on.
And the fourth point.
That's the pre-litigation advantage. By demanding specific pension documents, the trustee, novation agreements, that kind of thing, right in this first letter, you're basically forcing their hand early. They have to show you evidence that could really help your case, or maybe even reveal they didn't comply with the rules. Plus, it shows you've done your homework, your due diligence. That looks really good if you do end up in court.
Okay, so the why is clear. A unified strategy packs a punch. Now, let's dig into the specifics of the claims themselves. What exactly are the core problems this individual, John Michael, is pointing to, with both the termination and the pension?
Yeah, the factual background laid out in the brief is pretty specific. You've got this individual, John Michael, employed by RBTT Bank in Trinidad and Tobago. He was an estate constable there for about 12 years. Then, boom, October 19th, 2015, he gets a termination letter, effective end of the month, October 31st. But here's the kicker. The letter comes on RBC Royal Bank letterhead, and it's signed by someone just identified as head enterprise operations. Critically, there was no proof given that this person actually had the legal authority, the right to fire him on behalf of RBT Bank, his actual employer. And very importantly, he never got any notice that his employer was changing or any kind of novation of his contract.
Hold on, novation. What does that mean in this context?
Good question. A novation agreement, it's basically a legal way to swap out one party in a contract for another. So for John Michael, it would have been the formal legal step to transfer his employment contract from RBTT Bank over to RBC Royal Bank. Without that, legally, RBTT was still his employer. And maybe the most telling detail, his pension. It's still under the RBC Financial Caribbean Pension Plan, managed by RBC. That strongly suggests they still have ongoing obligations to him despite firing him.
Wow, okay. So based on those facts, what are the actual legal claims being made?
Well, they break down into a couple of key areas, and they're really intertwined. First, a clear breach of the Retrenchment and Severance Benefits Act, or RSBA, specifically Section 4. You can think of the RSBA as the rule book in Trinidad and Tobago for how companies have to handle layoffs, redundancies. The sources point out specific failures. They didn't give the required 45 days notice, that's Section 4.1. There was no consultation, no effort to mitigate, which Section 18 requires. They didn't notify the Minister of Labor. And like we said, the termination came from someone or some entity seemingly without the authority to do it.
Okay, so multiple violations of the redundancy law. What else?
Second, a fundamental breach of the employment contract itself. Because there was no proper legal transfer and no novation, RBTT Bank was still technically his employer. So the termination was carried out by a party RBC, or this head of enterprise operations, who lacked the actual corporate authority. That's a major breach of his contract with RBTT.
And then the pension piece ties it all together.
Exactly. That's the fiduciary breach pension mismanagement. Now, a fiduciary, like a pension trustee or administrator, has this really high legal and ethical duty to act only in your best interest. When they mess up, especially with retirement money, that's a serious breach. RBC, as the administrator, owes John Michael these duties. And the sources are really clear. Moving the pension management from RBTT to RBC wasn't just a paperwork exercise. It needed formal steps, like amending the actual pension plan trust deed, sending written notice to all the members, and potentially getting the okay from financial regulators, the central bank, the Board of Inland Revenue. The key point, John Michael got no notice of this transfer, no documents confirming RBC legally took over as trustee. So the fact that RBC is still managing his pension, it just flat out contradicts the idea that they completely severed the employment relationship. It points strongly towards ongoing duties.
You can really see how tangled it is, but also how the strategy cuts through it. Okay, so the grounds are laid out. What specifically is being demanded from the company, and what's the timeline?
Right, the relief sought section is sharp and demanding, and they have only 14 calendar days from getting the letter to respond. First, they want a written admission that the termination was unlawful, void, basically admit they messed up. Second, they want him reinstated, or, if not, compensation according to the RSBA, severance pay, unpaid wages, accrued benefits, the whole package. And this is crucial. Within just 7 days, they demand full disclosure of key pension documents. We're talking the trust deed, the plan rules, any amendment or novation agreement showing the transfer of responsibilities from RBTT to RBC, plus confirmation of his membership status, his years of service, his benefits, everything. They also demand correction of any wrong information given about his pension and proof the plan meets central bank and Board of Inland Revenue rules. And finally, confirmation of who legally issued the termination and a written promise they'll sort this out voluntarily to avoid court.
14 days for the main response, but only 7 for those critical pension docs. That's fast.
Very fast. The notice period is strict. The sources state clearly, if there's no constructive response within 14 calendar days, it's straight to the industrial court for the dismissal claim and the high court for the fiduciary breach. And they explicitly say that this letter and any failure to provide those documents will be used as evidence that the company didn't follow the pre-action rules.
Now, there's an interesting bit about why this is happening now, years later, an explanation of delay. Can you walk us through that?
Yeah, it's quite specific. The individual, John Michael, didn't immediately pursue his own case because his union, the Estate Police Association, advised him that a larger case, a special tribunal case known as ST-0615, would cover his situation. But then something happened in 2024, a judgment from the Judicial Committee of the Privy Council.
Right, the Privy Council, that's the final court of appeal for Trinidad and Tobago. Correct. So a major ruling.
Exactly. And following that ruling, he reviewed his own termination and pension situation again, realized the extent of the breaches based on this new legal clarity, and that's what prompted this current action.
Okay, so the delay wasn't just him sitting on his hands. It was based on advice and waiting for this significant legal development. Strategically, does citing that Privy Council judgment help his case now?
Absolutely. According to the sources, it provides a very strong justification for the timing. It shows he was acting reasonably, following guidance, and waiting for legal clarification from the highest court. That 2024 judgment likely provided the crucial insight or legal precedent that made the breaches crystal clear, giving him a solid, timely reason to act now. It actually frames his delay as diligent, not negligent.
That makes a lot of sense. Okay, so sending the letter is step 1. But it's not just about firing it off, is it? What are these additional steps to maximize impact the sources mention? How do you make sure this letter really lands?
right? These are the practical things that make the strategy work on the ground. First, verify recipient details. You have to get the company names and addresses exactly right. Is it RBTT? Is it RBC? If RBTT was fully bought by RBC, the letter needs to go to RBC Royal Bank, Trinidad and Tobago, Limited, as successor to RBTT Bank, Trinidad and Tobago, Limited. Details matter. If you can find the name of the general counsel or head of HR, even better. Precision is key.
Get the address right, basically.
Exactly. Second, the delivery method. Send it registered mail or courier. You need proof they received it and when they received it. That starts the 14-day clock ticking officially. And yeah, email a copy too if you can find the right address for legal or HR. Cover your bases.
Proof of delivery. Got it.
Third, gather supporting evidence. Pull together everything you have, your employment contract, that termination letter, any pension statements. You mention these in the letter to show you have proof, and this is about, you don't actually attach them to the first letter. You just say they're available or you'll produce them in court. Keep your powder dry, so to speak.
Okay, don't show all your cards at once. Makes sense.
Fourth, and honestly, this is probably vital given how complex this is, consult a lawyer. The sources strongly advise getting an attorney in Trinidad and Tobago who knows employment law and trust law to look over the letter before you send it. They can double-check all the legal references, the RSBA sections, court rules, make sure it follows the pre-action protocols perfectly, and they can advise on any tricky issues like potential statute of limitations problems because of the time passed.
Definitely sounds like money well spent in this situation.
Almost certainly. And finally, prepare for next steps. Be ready for what happens if the company doesn't play ball or doesn't provide those pension documents. The sources suggest you might then escalate the pension part to the regulators, the central bank, Board of Inland Revenue. Let them know the company might not be complying. And obviously be ready to file those court actions, industrial court for dismissal, high court for the fiduciary breach if you don't get a satisfactory response in those 14 days.
It's incredibly thorough. Every angle seems covered to maximize pressure and ensure they have to respond seriously. You also mentioned earlier, and the sources emphasize this, not sending a separate letter just about the pension. Why is that specifically discouraged?
Yeah, they're quite clear on that. Firstly, it's just redundant, right? The main pre-action letter already asks for all the same pension information. But more importantly, from a strategic view, sending a separate pension inquiry might signal to the company, oh, they see the pension as a separate issue. That potentially weakens the core argument that the termination and the pension mismanagement are fundamentally linked. You want them to see it as one big interconnected problem they have to solve.
Right. Keep it all tied together. Don't let them divide and conquer.
Exactly.
This whole deep dive, it really highlights how smart, strategic legal thinking can take what looks like a complete mess, multiple companies, different legal issues, and turn it into a clear, forceful plan. It's really not just about knowing the law, is it? It's about how you use it.
Absolutely. And if you zoom out, look at the bigger picture, this case really underscores how important it is to understand the specific rules around employment, around corporate takeovers, around pension management. Even though this example is from Trinidad and Tobago, the underlying principles, employer duties, fiduciary responsibilities, the power of a really solid pre-litigation strategy, those apply much more broadly. Getting that pre-court phase right can be absolutely make or break in resolving complex disputes anywhere.
So thinking about this whole strategy, what stands out to you, the listener, about how precision, putting all the pieces together, and really understanding the process can amplify the impact of any kind of communication, especially when the stakes are high, maybe even outside the legal world, something to think about.